So a new case is seeking Supreme Court review, and this one is in relation to a man losing his rights to possess firearms because of a misdemeanor. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So the case we're going to be talking about in this video is Harley v. Garland. This case is in relation to a man losing his rights to possess firearms because of a state domestic violence misdemeanor that he obtained. Mr. Harley, who is now 58, filed a lawsuit in the Eastern District of Virginia against the ATF, seeking relief from the courts to bar the agency and others from preventing him from actually being able to be in possession of firearms. His case is an individual, personal, as-applied challenge to Section 922G on the basis that while the statute is constitutional, it nonetheless is unconstitutional as applied to him individually. Now, real quick, I want to stop to explain the difference between an as-applied challenge and a facial challenge when it comes to constitutional litigation. In an as-applied challenge, litigants contend that a law is unconstitutional as applied or enforced against their specific situation. Facial challenges are where litigants claim that a law or statute is unconstitutional on its face. So in facial challenges, you allege that the text of the statute itself is unconstitutional, versus as applied challenges is a challenge to where you say the statute's impact as applied to you individually is unconstitutional. Now, the facts involved in this case are that in 1993, now about 28 years later, Mr. Harley was convicted of a misdemeanor domestic assault pursuant to the Virginia Code Section 18.2-57.2. He and his then wife had an altercation during which he was outside a Ford Bronco and she was behind the wheel and the engine was actually on and the car was running. When the vehicle rolled forward and stopped, he then jumped on the running board of the vehicle and tried to reach in and turn off the ignition switch. She then, I guess, pushed him, and before he fell, he decided he needed to grab onto something and try to hold on, so he reached out and grabbed, and what he grabbed was her arm. Well, after this incident, the wife then went to the local agency, the police agency, and actually sought the warrant and arrest of him because she claimed that it was a domestic assault. Now, in relation to this incident, he did ultimately plead guilty in about 1993, and he received a minimal fine of about $75 with no other penalty being attached to this incident. Subsequently to this whole issue, his ex-wife now has stated that this was a one-time event. The event did not involve them ever being punched or slapped or them hitting each other. This was just simply those facts of him reaching out and grabbing her arm. Well, in Virginia, any offensive touching constitutes common law assault and battery. And as a result of him pleading guilty to this issue and of those charges, he has now run into various other issues with the Section 922G of the Gun Control Act, which actually prevents him from being in possession of firearms because of this domestic violence issue. Now, the question presented for the Supreme Court to review in this case is, can there be a personal, individual, as-applied challenge under the Second Amendment to a prohibition on the possession of a firearm for the protection of hearth and home, which contends that the statutory ban at issue, in this case, 18 U.S.C. Section 922G9, is constitutional, but that is not constitutional when applied specifically to the individual person raising the challenge because of their unique and individual circumstances. So I know that was a mouthful, but essentially what he is arguing is that the GCA provision is constitutional on its face, but when applied to his specific situation, it is not, and therefore should be deemed unconstitutional, and he should be allowed to bring this type of challenge to that statute. Now, in this cert petition, two main arguments are presented to why the Supreme Court should actually hear this case. First, they argue that challenges to constraints on Second Amendment rights should not be more circumscribed than those on First Amendment rights. Second, they argue that the split in circuit courts on individual as-applied challenges warrants a Supreme Court review now. In their first section of the cert petition, they argue that, as allowed in First Amendment cases, individuals have been permitted to bring personal as-applied challenges to various statutes. Because of this, in the same way they argue that people should be able to bring as-applied challenges to statutes which restrict or prohibit a person's right under the Second Amendment to possess firearms for self-defense within the home. So really, this is a pretty straightforward argument. What they're saying is that we see in the First Amendment analogs that people are able to bring as-applied challenges to various statutes. And therefore, since the court allows those as-applied challenges in the First Amendment context, it should be allowed as well in the Second Amendment cases. They also argue that there has been no decision by the Supreme Court on whether an as-applied challenge is permissible under the Second Amendment, and as a result, there's currently a split in the circuit courts on this issue. Therefore, this case will allow the Supreme Court to resolve this lower court split all in once by addressing this case. They also argue in their cert petition that there has been no decision by the Supreme Court on whether or not as-applied challenges are permissible in the Second Amendment context. As a result, there has currently been and there's been a lot of split by the lower courts on this very issue of as-applied challenges. Therefore, this case will allow the Supreme Court to resolve this lower court split. One reason the Supreme Court actually does take up cases is when there is a lower court split. So here on this issue, there is in fact a lower court split on as-applied challenges and challenges to statutes as applied to various individuals, and therefore this issue is ripe for the Supreme Court to review. So this case is similar in some nature to other cases which were seeking Supreme Court review, but the Supreme Court denied review of those cases, and we don't really know why the court decided to kick those cases, but it could be maybe that they didn't like the facts or the legal issues involved in those, and it could be that they decide to actually review this issue because maybe there's cleaner facts and cleaner legal issues and just better arguments. So this case has not been yet distributed for conference for the Supreme Court to consider. This is just a cert petition, but also the Attorney General has filed their response to this case. So we will start to see some movement on this case, and we will likely see it be distributed for conference. We did have those cases, those 3 cases that I've mentioned in prior videos, get kicked, but there were 2 other cases that dealt with larger issues that were put on hold. So we will see what the Supreme Court does, but this one again is in a very gray area. Similar cases were kicked, so we will see what happens with this one. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys, I cannot thank you enough for all the support you've shown me for helping these videos to reach more people. Everything that you guys do that I ask, the like, comment, subscribe, notifications, all that, it really does impact these videos and impact the reach of this channel. So thank you so much, you guys. If you don't have a comment in mind, just comment down below. There's your comment to fuel the algorithm, and I really appreciate that. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this is Built by Armed Scholars, and Station we maintain by Armed Scholars.